morning, Mr. Shaw.
Good morning, Your Honor. Chief Justice Marshall, may it please the Court, my name is Robert Shaw. I'm privileged to appear today on behalf of Jose Arana. I want to make a critical distinction before addressing the specific first complaint issues in this case, and that is that what occurred in this case was a repetitive pattern of combined error in which the fact and or details of complaints were wrongly elicited, followed by demeanor evidence that pertained to those wrongly elicited complaints, further combined with the reactions of third parties to the complaint and demeanor evidence. And so this case is really resolvable on some what I would suggest are fairly extreme facts, separate and distinct from the discrete legal questions that the case gives rise to. Now, for purposes of analysis, I have broken down the first complaint violations into three distinct categories, and I'll address demeanor first. And I would suggest to the Court that there is an easy-to-articulate and apply rule that resolves the issue of demeanor. And that rule is that demeanor evidence is allowed from the first complaint witness and the complainant relative to the first complaint. And beyond that, demeanor evidence is not allowed in furtherance.
What if demeanor evidence is relevant to something? For instance, there's testimony that the complainant was always a very cheerful, happy person before, and then there's testimony that ever after, when they talked to the complainant, she was down in the mouth, despondent. Why wouldn't that be relevant? Forgetting first complaint, it would be relevant to her credibility.
Right, Your Honor, and I want to draw a very sharp distinction between demeanor.
Well, is your answer yes, it would be, or no? I don't understand by right what you mean, that yes, it would be relevant to her credibility, or no, it wouldn't be?
It very well may be relevant to credibility.
So why don't we say something like that, that if there's a reason for permitting demeanor evidence other than to establish or insinuate other complaints, then it's admissible in the judge's discretion and
right.
reviewable for an abuse thereof.
Right, and if I could just back up for a moment, I think the rule needs to essentially say that demeanor evidence is not allowed if it is in furtherance of, in connection with, or elicited in a manner that conveys a further complaint. Now, that would not be admissible, and that is exactly what occurred in this case. And I want to make a very important point here, which is that in order to get to the kind of demeanor violations that we have in this case, a prosecutor has to first violate the first complaint doctrine by eliciting complaint evidence that is not admissible beyond the first complaint. And it's only once you do that that you get to what happened in this case. Now, to draw the distinction, when you get to the issue of general demeanor, that is, demeanor elicited in isolation, unrelated to the circumstances surrounding disclosures that are not supposed to be admitted under the first complaint doctrine, that does not necessarily pose a problem. And in fact, in this case, we have that kind of evidence. If you look to Volume 5, pages 154 and 155, you'll see that in this case, there was general demeanor evidence elicited. It was elicited from the mother. It pertained to the time when she picked up the complainants the day after the evening in question. And I've taken no issue with that evidence in this case.
What's that cite again?
Volume 5, pages 154 and 155. That isn't to say, however, that the amount of demeanor evidence coming into a criminal case won't be a problem. And I would suggest to the Court that it seems necessary to reaffirm and perhaps remind the Commonwealth that it has never been appropriate to try criminal cases on the basis of emotion and demeanor. Excessive focus on demeanor with a theme to convict based upon emotion and sympathy is improper.
But you don't really need to get there. I mean, your problem, as you've just said, is really it's the trying to argue this is just demeanor evidence when it is very connected to a disclosure that isn't the first complaint.
Exactly. And it's very important to keep in mind that this case is a very extreme example, as I said in the beginning, of combined error. It is a repetitive pattern of eliciting the fact and or details, demeanor that then pertains to that wrongly elicited evidence, and then the reactions of third parties to the demeanor and the complaint evidence.
The Commonwealth would argue that they needed to do that because you attacked the victim as incredible or untrue. Let me suggest this and ask you what you would think about a modification to King to allow further complaints if the defendant attacks the first complaint as incredible or untrue or something like that, so that it's sort of like a prior consistent statement, which isn't allowed in until there's been an attack on the veracity of the person making the statement. But it would be only reasonable rebuttal, so that, and perhaps the defendant would have to tell the Commonwealth in advance. I'm not sure. I haven't thought it all out. But if either the defendant tells in advance or it's clear at trial that the credibility of the complainant is going to be attacked or that it's a fabrication, then you don't just let in more complaints that are just hearsay, but you let in the ones that are rebutting the incredibility or the lack of detail. Wouldn't that be consistent with King and just simply deal with something that King didn't address?
I don't think so, Your Honor, because King was a very comprehensive decision that...
It wasn't intended to address every situation that was going to come up. It was changing a doctrine, and even said, I believe, within King that we, are open to making further changes as we see what happens.
But King allows a full vetting of the first complaint.
Right, but then the complaint is attacked as incredible. You're lying, you made it up, this isn't what happened. And then would it not be, as I say, like prior consistent statement to let somebody say, no, I didn't make it up, see, I told B and C and D.
Well, but wouldn't, that's going to be every case.
That is going to essentially create a situation in which these criminal trials become about hearsay. I think the point being is that the complainant and the first complaint witness, and again, the complainant who can self-corroborate, can provide a full explanation of that first complaint.
But then, are we being unfair to the complainant and to the Commonwealth because we limited it to one, but then you attack the one and say that's no good, you're lying, and then the Commonwealth just has to sit there.
But, Your Honor, if a defendant attacks a complainant and does so by eliciting the fact that there were other...
cross-examination, right?
Right.
Cross-examines a complainant.
Right. There can be redirect, of course, pertaining to the complaint that's attacked. If the defendant is bringing up additional complaints or inconsistencies, there can be a redirect that rebuts and addresses that. If there is a prior consistent statement, here there wouldn't have been. In other words, there wasn't a prior statement that would have addressed that under these facts. But, the defendant can open the door as well, and in a measured way, in rebuttal, the prosecution can then respond.
I think surely the starting point here is why we admit the evidence in the first place.
Right.
There's no basis to admit the evidence.
That's correct. And the evidence...
So if we've decided that to have this repetitive and endless complainants bringing out more and more details, not of what happened, but of what she said happened.
Right.
Right? That is what King was designed to address.
Exactly. It was designed to essentially prevent it. And, I think it's important to get back to the original purpose of trials, which is somehow overlooked. It's to bring the witnesses before a jury, to allow the jury to listen to them, to allow the jury to assess credibility.
If we decided not to admit any complaint evidence, the victim, the complainant, might have to testify, and she would be the subject, or he would be the subject of cross-examination.
Exactly. That's the way it occurs across the country in, I think, just about every other jurisdiction but this one.
Well, the victim or the complainant is always going to testify.
Right. And King allows that complainant to provide a full explanation, self-corroboration, demeanor, all the things that weren't allowed under the fresh complaint doctrine.
Well, it allows them to do that in the absence of cross-examination that this is a recent fabrication. I thought that one of the things that we addressed or reasserted what our differences from essentially the rest of the country was, we allow first complaint, or we used to allow fresh complaint, even where there was no cross-examination of the victim as to recent fabrication. And I thought that in King, the first complaint rule was written essentially to address our continued interest in a general misapprehension as to the things that rape victims experience. That if they don't go screaming bloody murder, there must be something wrong. They probably weren't raped, and that was the primary concern behind King and the original fresh complaint doctrine. I thought in King we were trying to cabin it a little bit, but where the defendant does start to cross-examine about recent fabrication. Doesn't that open the whole door, as it does across the country? It opens the whole door.
It opens the door in a measured fashion. It's a basic evidentiary principle that, for example, just as an example, if the defense says, starts bringing up the issue of demeanor, that somehow the complainant's demeanor was just jolly and wonderful afterward, as a means of attacking credibility, that would open the door, certainly, to a response from the prosecution to bring in evidence of demeanor indicating otherwise.
Beyond first complaint.
Well, sure. I mean, and that I just used that as an example. I think that's true throughout a trial. But, what happened here is you have the Commonwealth who laid out a case that violated the doctrine over and over and over and
Mr.
over
Shaw,
and over again.
let me follow up Justice Spina's. If we look at the cross-examination of the complainant here, was there cross-examination saying that she had recently fabricated?
No, not recently fabricated.
Well, I thought the examination was that the way she described what happened in the first complaint was different than what she testified at trial. What she testified to at trial was more extensive than. I'm sorry, I didn't mean to interrupt, but isn't that a recent fabrication claim?
I don't think that's a recent fabrication claim, no.
You agree that the defense was directed toward the fact that she was telling more details at trial than she had told to that first little boy, whatever, first young man.
Your Honor, the defense was bringing out some inconsistencies in the way the statements were made, and that is going to happen in every single trial. King was very...
I understand, but that's the problem. I mean, that is the problem. We have to decide whether that it's fair to just let the complainant be attacked that way and then do nothing really to rebut it, because then she could say, well, I didn't tell everything to Chris or whatever his name was, but I did tell it to Betty the next day, or whoever she told it to the next day.
Well, Your Honor, King provides a mechanism for that. King allows the complainant to fully explain
Why she didn't.
Exactly. I mean, it allows it right from the start. It allows it before the defense does anything.
But in this case, it wasn't so much that she didn't tell the young man everything. It was that the young man didn't seem to remember. At least that's the gist that I get from the
Well, I think you're referring to the second complainant and
right.
Kerrigan. There was the first
All right,
complainant and
well, the second
someone named Jack
complainant
McCarthy.
I take it that, I mean, there have been cases where, for example, in a familial situation, there was evidence, brought out on cross-examination by the defense counsel, cross-examining the complainant, to the effect that you had just had a fight with your stepfather, or you had just had a fight with a school principal. In other words, that really goes to recent fabrication, correct?
There may be situations where prior consistent statements and the requirements for getting in a prior consistent statement are present in a case. If they are, then certainly like any other trial, that would be admissible. And the prosecution
what I
can
was
listen
trying to
to
do is I take it that is different than cross-examining a complainant as to whether the events took place.
Exactly, because that is going to happen in every single case, and certainly that occurring in a trial shouldn't open up the door to multiple further complaints coming in. And if I could just step back for a second, one of the things I want to address is the fact that the Commonwealth has provided many varied explanations for why it is that these violations occurred. I think it's important for the court to step back. I obviously don't have time to address all those detailed violations here.
Could you talk about the Bowdoin issue?
Yeah, well, I think, generally speaking, I think it's important for the court to step back and really look at what the Commonwealth is doing here, because what's happened here is that the Commonwealth has taken liberties at trial that violate the doctrine. Those liberties were not necessary to prosecuting the case at all. And now what the Commonwealth is doing is they are attempting to justify those violations to pointing to everyday, daily occurrences in criminal trials, such as the need for context and the need for foundation. Now, if this court was to accept those justifications, the court would literally be providing prosecutors with unbridled discretion to violate this doctrine whenever they choose to. And the fact is that no evidentiary rule and no doctrine is ever going to have any integrity or force if this can occur. And I think that prosecutors have an obligation that were not obligations that were absent in this case. The first is that they need to lay out their cases in a way that does not violate evidentiary rules when it's easy for them to do so. And the second thing is that the prosecutor in this case, if she did feel that there was a Bowden issue, she had an obligation to raise it with the judge. Happens every day. Your Honor, I believe I'm going to need to be able to respond to this. This is necessary. And then they can go to the defense and say, defense, are you going to raise this issue? If you're going to raise this issue, then there's going to be a right to respond. And that's just basic courtesy. It's the prosecutor bringing to the judge's attention that I'm going to skirt close to the line, or I might do something that I feel I should be entitled to do but would violate this evidentiary rule.
May I ask a favor? I'm sorry, but in an amicus brief, it was mentioned that the defense theory was that the victims had filed a $5 million lawsuit and fabricated the allegations for purposes of making money this way. Now, was that brought up during the trial as a reason?
Your Honor, the amicus brief refers to that as an extortion theory, essentially. The Commonwealth's brief doesn't even jump onto that. It's inaccurate. What the defense did here is they brought up the fact that there was this $5 million lawsuit filed. It was brought up in a very superficial way. I believe if you look at...
Well, if it's brought up, then why wouldn't that be a reason for the Commonwealth to ask the victim about other statements made to other complaints made before the lawsuit was filed to show that it wasn't, that the economics weren't a purpose here?
Your Honor, the theory for responding to that, the supposed justification, is to show reticence. Reticence was shown through the first complaint doctrine because King allowed the first complaint witness and the complainant to testify about reticence, concern about parents finding out, concern about drinking, concern about Mr. Arana's daughter, Cleo. Okay, so all of that was brought out. Now, if that really is a question of motive. If there's a issue about motive, the complainant can testify about her motive. You know, that's what trials are supposed to be about. I think the court needs to be very careful about saying just because some sort of issue is raised that somehow all these additional hearsay statements need to come in. Taking that approach is simply going to violate the doctrine.
Thank you, Mr. Shaw.
Thank you.
Ms. Lee?
Good morning. May it please the court, Mary Lee, Assistant District Attorney for the Plymouth District for the Commonwealth.
Ms. Lee, let me ask you this, and I haven't obviously looked at the transcript. Did the judge have King sort of at hand? Was the judge trying to follow King?
Yes. Yes, the prosecutor...
That was the impression that I had, that the judge had a copy of the decision, right? Because this was tried a year and a half or 2 years after King.
The trial was well after King. It was in the summer of 2007. It was prior to
That doesn't
Stuckich.
resolve it, but I mean, at least...
I have a
prior to
question.
Stuckich.
Obviously, I haven't read the transcript yet, and I'm confused from reading the briefs. Was there any evidence of any natural sexual intercourse between the victims and the man?
The victims did not testify to
So
natural
why
sexual
did the
intercourse.
Commonwealth go into the DNA and sperm, and why was that even relevant?
I think it was the Bowden issue.
But there's no allegation of any sexual intercourse, so-called natural sexual intercourse. So it would seem to me, I mean, I would think the judge should have ruled that whole line of inquiry irrelevant.
Well, the Commonwealth first wanted to show that the investigation was complete, but also
But you don't investigate.
Right, the
If
victim...
the moon is out that night, if lighting isn't relevant.
The victim, Marie, who's the younger, I'm calling her Marie for the purposes of
Sure.
the pseudonym. She's the younger of the two. She's 14 years old and 8th grader at the time. She testifies about the defendant when they're downstairs in the basement, and it's his final assault on her. And he... actually, I'm sorry, his first assault on her, and he has her touch his penis, and it is hard. And later on, down in the basement, in the second assault on her, he asks her, do you want to have sex, implying natural sexual intercourse? And she said no. And at that point, her pants and underwear were off, and he was beginning to become undressed. And so it's possible that there could have been.
Trials don't deal with possibilities.
It's possible that
We
there
know
could have
that.
been some
But there was no testimony.
fluid
There was
that could have been recovered.
from her vagina.
There was a rubbing of the penis against the vagina for a short period of time upstairs. And so in terms of evidence collection, there was not testimony about whether there was any emission.
How does that get into Bowdoin? And was there was no request for a Bowdoin instruction, was there?
No, but the closing argument certainly raised it, and the defense questions to the police officers raised it.
And that gets you to this, you think?
Did you ask them if they took fingerprint evidence here?
I did not.
Well, that would have been just about as relevant to a Bowdoin.
The defendant, on cross-examination of the police, asked when they were doing the search warrant at the defendant's house, did you videotape it? Did you take pictures? Did you
But
waited how long?
But that's totally different. That's not analogous. All right, go ahead. I'm sorry to have interrupted. Go ahead.
And that's quite all right. And in fact, this might be a good point to note that unless the court has questions regarding the discharge of the juror, I'll defer to my brief on that issue and focus entirely on first
actually,
complaint.
I do have a question about that.
I'd be happy to answer. Yes.
The question is this: why is it not? Seems to me that we tell jurors you shouldn't consider anything that happens outside of the courtroom. This was happening right in the courtroom. Why is that improper? Why shouldn't the juror be able to consider that?
Because it's a person in the audience. The case law is clear that a person in the audience taking actions can be an extraneous influence on the juror, and that's in Denson. The defendant's mother was in the gallery, and Hardy, the public actions during a view were both seen as extraneous influences.
But they were being manifested by the witness's demeanor. And one of the things the judges tell jurors that you can look at the witness's demeanor.
Right, and the judge's concern was that the person in the audience was having the influence on the juror as opposed to the witness himself and his demeanor. Rather, in fact, it was the person in the audience who was nodding his head four times.
But then the juror said it's no, absolutely I can be fair.
Right, and the question, when there's a discharge of a juror, is first, is there an extraneous influence? And the judge found that there was, and I would suggest that's correct under the cases I've just cited. And then the second factor is the judge must make a finding whether the juror should be removed because of a substantial risk that the extraneous influence will affect him. And you find that the requirement of findings is in Dunnington, and that standard can be found in Ashman. The judge followed that standard, and he found that he had a very strong feeling that the juror's mind was made up. And the judge found that the juror could not remain impartial despite his claim because he apparently believed the witness had been coached 4 times by someone in the audience. That's a proper standard under Giusti as well as Ashman. So I would suggest the judge made the appropriate findings. He followed the standard in the law. A person in the audience's actions can be seen to be an extraneous influence.
Yes, but if the juror says, and I won't pursue this, but if the juror says, I think this witness was coached, the juror is looking at the witness, right? I mean, thinking about the witness.
It was the combination between the person in the audience, Sweeney, and then the witness's answers.
So when a prosecutor is cross-examining a witness and says, answer my questions, don't look to the person in the audience, if the witness says okay, that's a mistrial because the whole jury has now seen that happen.
I'm not aware of a case like that. I would suggest that a proper thing to do is to go to sidebar and to address it with the judge if the prosecutor becomes aware that someone in the audience is having an extraneous influence, because it's for the judge to decide, and it would be not appropriate for an attorney to call attention to an extraneous influence to the jury. Usually those kinds of things are handled at sidebar. I'm sorry, does that answer your question?
Isn't that in essence what this juror was trying to do? Let's say a juror has a concern.
He was concerned, yes.
The juror has a concern and thinks it's, and the juror brings that to the attention of the judge, but then the judge says, well, can you be fair? Yes, I can be fair.
And the judge isn't required to believe that. It's the judge's job to make the findings based on what he sees to determine if there's a substantial risk that an extraneous influence by the audience member would have affected juror number 4, and that's what the juror found. And the defendant in this case would then have to show an abuse of the judge's discretion. He's the person who talked to the juror, viewed everything that was going on. He also had heard the voir dire testimony of that witness. It's Christopher Kerrigan, who was the first complaint witness for the younger victim, the first complaint witness for the younger victim. He's the first complaint witness to testify because of the other victim. He used the appropriate standard. He was not required to adopt the juror's statement, although he certainly took it into consideration, and I would suggest the defendant has not shown an abuse of discretion on that issue.
Moving on to the
First complaint.
complaints that were made, why was the prosecutor allowed to, I'm not sure that this came through, why was the prosecutor allowed to ask B about her statements to her parents? B had already given her first, testified to
Who has a
whom
statement
she
to
had
the parents.
complained, but then why was testimony about her statement to her parents allowed to come in?
Right. This is a problem of timing, and again goes to the context of the statements in which they're made. And I would note that, first of all, when the prosecutor asked Betty, who's we're referring to as the older person, no evidence actually came from Betty on that. And so the jury were instructed that questions are not
But
evidence.
why did he ask her? Because you've got your
Yeah,
first
sure.
point. We've said no more. Why?
Sure.
And what is the timing anyway relevant? I know you're trying to explain the delay in going to the
The
police.
delay for the search warrants, yes, exactly. So I would suggest that there's some confusion in the law, and clearly
But you get that by just one question to a police officer. When did you first learn about this? I first learned about it on Saturday. Okay, so I didn't get the search warrant until Saturday, even though it supposedly happened on
problem is
Monday. And there's the answer.
The first time she went to the police station, she's hysterical crying, and she doesn't disclose. There's no disclosure that night.
So, all right, but why was the statement
then-
to the mother let in?
Right, because the mother is the one who called the police department to tell them. So that's when they're on notice
So
that there's
what?
a disclosure.
If the police are making an investigation, they were obviously notified by somebody.
Right, but in this case, the defendant was asking, why was your search warrant so late? This crime happened on
And the
this
answer
day.
is because I wasn't notified of the details of the event until the day on which I applied for the search warrant. Period.
I would suggest that's what the Commonwealth was trying to bring out.
Yeah, but you brought it out by getting into many additional complaints.
Well, let me just say this. Under every other case that we deal with in Massachusetts,
Yes, but these
the
are
law of
different.
evidence.
We let in hearsay in this case, and we don't let in hearsay
In every other case, it's not hearsay. It's non-hearsay. Under Carlson and under Smith and under Cordell and under Cruz, when there is a fact of a conversation and what a person does after it, then no content is offered. It's not hearsay. It's a well-accepted
Ms. Lee,
position.
would you prefer that we just end all first complaint and then rely on our normal rules of evidence? Because the problem seems to me, and I accept your representation, but the problem is, the concern is the piling on. So you have nobody, you have no first complaint hearsay statements, zero, and you let the trial proceed.
Well, I think the problem, from the Commonwealth's perspective, is that fresh complaint is a hearsay exception, solely applicable to sexual assault cases.
Correct.
Well, it's not a hearsay exception because we don't let it in for the truth.
It's like prior inconsistent statements. It's a hearsay exception that is permitted for a limited purpose, corroboration only. As I read King, I thought the intent of this court was not to cut out every other hearsay exception that exists.
Well, it may be, what you're making, to me at least, is an argument that says, it doesn't work. And the reason why I asked you whether the judge had the opinion, I mean, this is who was the judge?
A very experienced judge, Judge Brabo.
Brabo,
Yes,
yeah, I thought it was
yes.
Brabo. Very experienced judge. He's got it there. And he's trying.
Sure.
And so maybe the best way to go is simply to say, we have reached a time where that's not necessary, and if the defense wants to raise issues like, why did it take you so long to do the search warrant,
Then the
you-
notice to the police comes in.
in whatever way, right?
No, the Commonwealth certainly would be entitled to demonstrate the notice to the police is significant because of the,
So you don't allow any first complaint. You don't establish an exception to the hearsay rule because it creates too many problems.
well, the problem with that is that in King, in this court, you recognized, and particularly in footnotes 19 and 20, that those unfair biases that sexual assault victims are liars still exist. And so in King, you came to and the hue and cry, and you came to the conclusion that they needed that extra help
I
of the first
understand that,
complaint doctrine.
and maybe the
And
rule
so
but maybe the rule that we try to establish, we also recognize the tremendous problem of piling on. And the problem is, if you take a case, for example, where, let's say there was no first complaint, right? And the defense, for whatever reason, to the police officer wants to ask about why did it take you so long. It seems to me it's practically ineffective assistance of counsel, but leaving that aside,
Right.
they want to go into that area. For
It should all
whatever-
come out fully.
No. So then you get the mother to explain. That's not piling on because you haven't led in.
The
Right?
initial content of the first complaint.
Correct. So
What
you
I
then.
would suggest to the court, the way first complaint is being used, and this is why I made my first argument asking this court to reconsider King, is that if you have a rape of a stranger by a stranger or a robbery by a stranger, you're going to see that the evidence rules are now being very restrictive in rape cases.
No,
So
I
you
know-
have
I
a 911 call comes
I
in.
understood that you.
Help, I've just been attacked. Person in a Raiders jacket just drove off in a white jacket. Help me, hurry, I'm hurt. In a robbery case, that's coming in. Substantive evidence as an excited utterance, no problem. In a rape case, there's at least going to be an argument and possibly a ruling that only comes in for corroboration under first complaint. Then the police go to the scene and they're able to testify. I talked to this person, the victim, and I left. I went, I stopped a white car. I saw a Raiders jacket in the back seat.
I
Got the guy,
understood-
brought him back.
I understood your
In a
argument.
rape case, they're going to say that's a fact of an additional complaint because the 911 was the first complaint. It doesn't come in.
Well,
But
there's
in
no
every other
complaint in
case,
that. There's no complaint. There's no complaint issue in that. I went and I stopped somebody and brought him back.
but
for
I had a
ID.
conversation with the victim, and based on that conversation, I went. That's exactly what happened in this case. I had a conversation with the victim 2 days after her first arrival. This is Betty. For 2 days after her first arrival in the police department, which she did not disclose. And today, 2 days later, she had a 15-minute conversation with me, and I took out a search warrant. I got a search warrant and an arrest warrant, and then a few days later, we executed the search warrant. That's what happened in this case. And they're saying it's inadmissible.
I have a question about all these other states. Most of the states don't have any first complaint. Then what is the defense, and does the defense in most of these cases end up opening the door? Because once you attack the victim, I mean, how many ways can you attack? You say it didn't happen. She says it did happen.
You still don't get in the.
No, right, but then what is the other defense if it's if it is a non-stranger?
I think, if you recall from my argument in King, that it's not so simple that every other state doesn't let that stuff in. Other states have the child hearsay bills and let those statements in, even without the testimony of the children. If you recall from my argument in King, they have, it's not simply cut and dry. They are apples and oranges. What other states do and what we do is different, because other states, if you recall, were letting it in substantively from my argument in King. And I said there would be a Crawford issue coming up on that because we were doing it better than other states.
Is it your view that impeachment of a victim by prior inconsistent statement is tantamount to recent fabrication or a claim of recent fabrication that permits prior consistent statements?
No, because the first complaint comes in specifically in sexual assault cases, and it doesn't require having the inconsistent statement
And that's not my
first.
question. If a defense lawyer gets up and says what you're saying here today is inconsistent with what you told the first complaint victim, does that automatically open the door to all other prior consistent statements?
Well, certainly the judge would have discretion as to how much could come in, but certainly we can answer it when the defendant has opened the door, and the appeals court answered that in the Pereira case.
So impeachment by prior inconsistent statement is tantamount to recent fabrication.
I don't think I would go that far, but it certainly should permit some answer, as the Pereira case has found in the appeals court. And I would specifically point to the defendant's opening in this case. Defendant's opening started at the evidence will show that Marie originally gave a written statement to the police, Duxbury police, saying nothing happened. The evidence will show that Betty's versions of the events have changed. There's no forensic evidence that corroborates the girl's stories. And you will also hear that the family have filed a $5 million civil lawsuit. The defendant opened the door in his opening statement. I would suggest that this evidence was properly admitted, and I would ask this court to affirm the convictions. Thank you.
Thank you, Ms. Lee.
No, go for it. Thank you.